dispute, because in some of the termination notices, it talks about some current, like in Sudan, for instance.
Right. So just to be clear, we're not conceding that we
Right.
did not do that.
On the other hand, if you look just on the face of the notices compared to the extension notices, the previous extension notice, and the current termination notice, there are a number of factors that were just not addressed. If you look at El Salvador and some of these other countries, the termination, the extension notice noted certain things, problems, but they were not, it was just silent in that regard. So sometimes they're addressed, sometimes they're not.
And that would be true for every TPS termination since the H.W. Bush administration. I think if you look at them all, you will see that some are voluminous in their discussion, some are pretty somewhat short.
The prior terminations also omitted discussion of the previous condition that had been cited in the preceding notice.
If you reading the prior Federal Register notices, you can't discern any pattern of consistency where every single factor that was ever mentioned in the prior extension is rebutted in the termination. It's just not the way that these have been handled.
Well, that does raise a disputed issue, but assuming for the moment that if the plaintiff were able to prevail and show that there was a significant substantive, or they put it sudden change, wouldn't that be problematic under the APA, since there's no explanation for that, no reasons set forth?
No, Your Honor. Again, not getting to the merits of whether this actually happened. None of the cases that plaintiffs cite for the APA claim are like the situation here. They all involve some sort of prior public notice given to the public about how the agency was going to administer or prosecute a particular statute. There are none of the reliance interests that those types of public statements would have engendered are at issue here. And this is a temporary humanitarian program applied by different administrations over since I guess 1991, and to try to stitch together a policy based upon inferences in the Federal Register notices and imply one that exists, and then that would be binding on future administrations unless there was a public statement that they were changing course, would be outside of the framework of the APA.
Are you suggesting there has to be a sort of proven reliance interest in order to implicate the APA's requirement of some reasoned explanation for a change?
Not that there's a reliance requirement, but that in all of the cases that plaintiffs cite, you're dealing with formalized public communications, like either proposed rulemaking or, as in FCC v. Fox, you had interpretive guidelines that the FCC was publishing about its fleeting expletive policy. And I mentioned reliance in that context because it is there where, in that context, where the Supreme Court in Fox the FCC says, the agency has to give some reason to explain what it's doing and notify that it's doing so. Without any prior express policy, there would be no requirement to publish on the website or anywhere else how they were administering TPS.
Well, I know you would argue that Fox, for instance, the FCC Fox case is different because it concerned formal policies and regulations, but the APA principle about having to at least discuss and explain changes have been applied to practices, not just formal policies. In the American Wild Horse case versus Purdue, I think that was a practice regarding how certain lands were treated. I don't think there was a formal regulation, as I recall.
But it's not so much that it was a formal regulation, but it was a public policy that had been in place for 2 decades, I believe, or maybe more than 2 decades.
And, well, I take it what we're going to hear from the plaintiffs is that there's been a public policy or practice of accounting for intervening current circumstances before terminating, and that is the change. I mean, it was public in a sense that if you look at all the explanations and the extensions, what the practice was is made evident and was public. So why is that any different?
Well, maybe this just collapses to the merits, that's just not the case.
Right.
And Your Honor, also, I know that we started this hypothetical with the proviso that there was jurisdiction, but I just want to reiterate that the APA itself would deprive the plaintiffs of this court of jurisdiction over that claim because of Section 1254A.
Right, the jurisdiction stripping provision. Right, which is why I started, because that's a threshold question, and if the government prevails on that, then none of this is cognizable. Or,
I just wanted to reiterate that point.
All right. Let me hear the response regarding the APA.
Your Honor, I'll start with this question of whether a rule has to be explicitly and formally written down for this general principle that an agency must explain past departures to apply. As Your Honor said, many of the cases that we've cited do not involve that situation. So in American Wild Horses, it was a practice over years. And also the...
was that practice embodied in any or described in any public... in other words, here there's kind of an implicit, you're asserting an implicit practice, an implicit policy. In Wild Horse, was that implicit or explicit, the practice of how certain lands were treated?
I think the case most on point with implicit practice is the FERC case, but the Wild Horse, the FERC case, the California Public Utilities versus FERC. In Wild Horses, the situation was that the agency was taking a very similar position to the government. Here, they were denying that there had been any rule that was ever changed. And in rejecting that argument, the court looked in part to practice. So the agency had to count the number of horses that were in this disputed territory. And they said, in your reports where you count the number of horses, you counted the horses from this middle territory. So clearly you thought the middle territory was part of the reserve. There was also an original forest plan that was incorporated by reference into another document that said that the reserve was part of the, that this disputed territory was part of the reserve. So the court looked at both things. The FERC case is a case where the rule really was embodied in individual decisions, just as in our case. So the over the course of deciding several cases, the issue had to do with whether you could give an incentive to a utility company for being part of a group that it had no discretion to leave. So there were incentives given to electricity companies when they made a voluntary choice to join certain groups. And the question was, could you give the incentive to a utility company that had no choice but to be part of this group? And in the past, the agency had always denied, in individual cases, the utility company would ask for the benefit, and they would say no, because your participation in this group is not voluntary, so you don't get an incentive to induce your behavior. They changed that not in a formal announcement, but in a decision granting an incentive to a utility company that was part of this group and had no discretion to leave. And so the policy, and the court actually says this in the decision, but the policy that was departed from was embodied in prior decisions. It's also the case in the Bonneville Power Administration case, Your Honor, where the practice that was departed from was that the agency would always fund a fish passage center whenever this other body had recommended they do so. It was just in a practice. They didn't have any rule always fund them when the other body says. So it was just a practice. So.
All right, well, that brings up the question, how clear, and maybe this is the factual dispute here, your theory, your APA theory, and perhaps your, in part, you're seeking to avoid this jurisdictional stripping provision, hinges on the existence of a new policy or practice. What's your response factually to the fact that if you look at earlier terminations, many of them also did not refer to prior extension conditions, and one could argue it looks like there's no clear pattern here, that you don't always consider all conditions.
Well, Your Honor, the first thing I want to clarify is that this practice of considering intervening conditions and describing the intervening conditions and the extensions and terminations is one that developed over time. So the initial termination and extension notices are quite cursory. there's a giant folder there with all of them. But the initial notices in the 1990s are quite cursory. It's around 2000 where you start to see more detailed explanations in both the extensions and the terminations. Obviously, you can't have one rule for terminations and one rule for extensions, so you can't only look at one. As Your Honor has noted, this is a factual question, so to the extent there's any ambiguity about what was considered at this stage, it has to be construed in the light most favorable to the plaintiffs. But there is a clear difference between the factors, the intervening factors that are considered before the Trump administration and after about 2000. Because before that, the notices just say very little. But there's a clear difference between the reasons that are given in that 17-year time period and the reasons that are given under the Trump administration.
Well,
We've also,
is it accurate that there were prior terminations that didn't address all of the immediately preceding extension justifications?
the government has cherry-picked a few examples that they have discussed in their brief that they argue show a failure to consider intervening conditions in terminations. At best, we think those are cherry-picked examples, and that the overwhelming pattern is to consider intervening conditions in both extension and termination notices. To the extent there is no pattern, and the government sometimes considers them and sometimes doesn't, that would also be a violation of the APA to apply one rule in one case and another rule in another case arbitrarily.
I don't recall that being a theory you advanced. I thought your theory is that there's a change, not that there's been inconsistencies from time to time. Therefore, prior administrations may have violated the APA as well. I thought your position is that this administration has violated the APA because of a sudden and new change. So that's a different theory.
You're correct, Your Honor, and I apologize if I was confusing. That is our position. In response to the government's argument in our opposition brief, we point out that if the court accepted their version of the facts as true, and sometimes factors are considered and sometimes they aren't, that is a different APA violation. That's not the one that we have alleged here, but that also would violate the APA.
Are there any cases that say how much of a change, how clean, how categorical a change must be in order to invoke the requirement of providing good reasons, et cetera, for that? If there's a subtle shift from, 60% explanation to 40% explanation instead of 0 to 100, 100 to 0, are there any cases that say at what point, how significant, how substantial, how sweeping, how complete must a change be before the APA is implicated?
There aren't any cases I'm aware of, Your Honor, that directly address the question, but you can look at the changes that have, where the court has applied this test. So in the Fox case, for example, the change is one expletive enough to count as indecency, or could two count as indecency? And the court explicitly noted that the agency didn't change the definition of indecency, it just changed how it was applied. There's also in the Bonneville Power Administration case, Your Honor.
But there you could see what the change was in a fairly graphic way, right? I mean, here you're looking at a pattern. I mean, as you say, they cherry pick, but if they can cherry pick enough, then it begins to look like not so discrete a pattern. If there's enough examples of that.
So the question is not how, I apologize, Your Honor, I think I was misunderstanding the question, not how subtle the change has to be, but how clearly the change has to be expressed.
I guess that's a better way of putting it, yes.
We think that the change is clear, Your Honor, from the notices, but we have also alleged numerous statements that reflect a change. And so it's not just the notices, but it's, for example, Secretary Nielsen saying, the law does not allow me to look at the conditions of a country writ large. Compare that statement with pre-Trump extension and termination notices, there is a clear change.
All right. Now, to the extent that raises a factual issue, why isn't this, explain to me again, why is this not, to go back to the first question, a fact-based challenge to jurisdiction as opposed to a facial challenge? And if it's a fact-based challenge, doesn't this court have isn't it charged with having to resolve that fact?
Because the government's position, Your Honor, is that there is no jurisdiction over our claims, regardless of whether we can prove a new rule or not. Their position is that the court doesn't have jurisdiction to consider whether there has been a rule change.
So it's the nature of their challenge. They're saying even if true, there's still no jurisdiction.
That is how I understand it, Your Honor. And we briefed this in our brief from yesterday, and my co-counsel may be able to elaborate about that.
All right. Well, let me clarify from the government. I know that is your argument. You've made that argument, but and is that the gist of your jurisdictional challenge, that even if they could prove it, this statute is so broad and sweeping and unconditional that it bars judicial review?
That is our position, Your Honor, yes. And if there was one thing I might add to the APA discussion.
Yeah.
This theory of bringing this within the rubric of the APA threatens to imperil the TPS framework itself, because it would not just be terminations that would then be subject to litigation. It would be the designations in the first instance.